All right, welcome everybody to this week's edition of your credit repair pre-litigation disputes training course interactive show. And for those of you guys joining us live, feel free to chat in your comments below. And if I don't answer you, yell at me, get my attention because I didn't notice it. And if you are watching the replay, chat me, tag me, and we will get you all commented up in Facebook. All right, well, let's go ahead and just jump right on in here. So let's open up our agenda. Who am I? Why am I here? Is what you are wondering about yourself. Well, let's open this. Let's open this up here. So actually, this is your training course, your pre-lit course, where we teach you how to do pre-litigation disputes every Tuesday, except for today when I'm late because my Zoom was actually giving me technical difficulties. Every Tuesday, 11 to 11:30 Central is our pre-show, and 11:30 is when we start this the actual live session here. And then once a month, we have our sidebar as well. All right, we have this law library worth the cost of admission in and of itself. This thing's about $2,800 a year, and it's legit. We pay a surcharge to share the credentials with all of you, so take full advantage of it. And we're going to reference this on today's episode. And in the Facebook group, we have all of these guides / modules of content built out. Take full advantage, take a look, and let me know what is going on. All right, so that's what's up. So for today, first up, we've got Scott Schaaf is doing some arbitration, and I really like what Scott does because, well, he does it the right way. He kind of like says what he means and means what he says, and he can back things up. And so he has an arbitration with Credit Acceptance Corporation, and basically the skinny of it is that the issue he's got a problem with is that they're reporting 180 days past due for a long time, and that's a problem. And we're going to talk about why that's a problem. And Scott pointed out that that's a problem, and so let's just kind of go through his screenshots here. So, all right, so here it looks like a screenshot from I guess the attorney or whoever representing Credit Acceptance in the arbitration. So it says, Scott, thanks for your message. Can you provide any legal basis for your claim that a debt must be charged off after 180 days, 120 days, excuse me. Okay, so basically the argument Scott is making is that this is inaccurate credit reporting. Welcome, George, by the way. This is inaccurate credit reporting because it can't be 120, 150, 180, so on and so forth. Now, I don't have a copy of the report, but you guys can get the image. This Credit Acceptance was reporting late for a long time. Okay, so here's kind of the message back from the arbitration, I guess, defendant attorney to Scott. Okay, so then Scott, he posted this up, and this is kind of the golden jewel. We've talked about this since the beginning of us starting this course, is the charge-off policy that these big regulators have. Okay, so Scott is telling, I guess, the attorney on the other side for Credit Acceptance, here's a link, screenshot where this rule, you can find it. Okay, and so here's what Scott says. The way that your client is reporting, the way that Credit Acceptance is reporting the accounts on credit reports means they could report an account as 120, 180 plus late, depending upon which credit bureau. And he's saying, obviously, TransUnion only goes up to 120 plus, which is a problem in itself. But that's not because Credit Acceptance is reporting wrong, right? That's because TransUnion just gives crappy reports. Okay. It could be, so he's saying it could be 10 years from now, and you're still reporting 180 days late because they never charged off the account as a loss. So he's saying, I look at the reports, apart from the fact that TransUnion is garbage and doesn't even report anything ever over 120. But if I look at the reports, you guys would report 120 or 180 forever because it's suggesting you never charge off the vehicle. And he's saying you need to charge off the vehicle. Also, it would allow for continuous derogatory information to be reported without the normal 7-year time frame for negative accounts. Let me clarify your point. Let me just pause real quick. This is very well written. Again, Scott's doing this as part of arbitration. So again, this is really like driving home pre-lit is you got to know what the hell you're doing, right? And you don't just throw the spaghetti against the wall, spray and pray. Okay, so however, the date of first, okay, let me clarify your point on an account not reporting after being charged off. An account can continue to report after being charged off as a charge-off. However, the date of first delinquency, which is the first late payment in the series of late payments that led to the account being charged off, is what determines 180 days, then 7 years it can legally remain on the credit. And that, notice Scott got that right. If you look at 1681C, 15 USC 1681C, that's where it actually says these can report for 7 years plus 180 days. Scott has paid attention in school. That date can never change. Also, the date the account was charged off will be noted and never change. So it will continue to report as a charge off, but will be an old charge off after several years while your client keeps. Okay, so it's important to note there's a date of first delinquency, which Scott's talking about, which is under the FCRA defined that for reporting purposes, it must go as it must go for reporting purposes after 180 days to some sort of collection charge-off type status. Okay, now that doesn't necessarily mean internally they have to do that, but for reporting purposes. Okay, but we're going to get to their internal thing here in a minute. Okay, so so it will continue to report. Scott, welcome, sir. Scott,
Hey,
we're going over your beautifully done here arbitration. You've been paying attention in school, I can tell. Okay, so it will continue to report as a charge off, but it will be an old charge off after several years while your client keeps it alive indefinitely. With how your client is reporting the account, there never is a date of first delinquency because they don't charge it off. Having 180, and that's good because the definition, and let's just talk about this, Scott, you are a gangster, actually. So we go to 15 USC 1681. This is what pre-lit is about, is because you got to know what the hell you're talking about. Okay, so 1681C talks about what the fuck happened to my screen share here? What happened there? Let's see.
Oh, I'm sorry. I think I clicked it off on accident, buddy.
Oh my goodness gracious here.
My bad.
oh my goodness.
Can you guys see it again?
That's what happens when you give me host privileges. I fuck up.
That's right.
Are we
That's
doing
right.
floggings now?
All right. Can you guys see me?
Yeah.
Okay, cool.
Unfortunately.
So right on, Scott. So information to be excluded, which would be information that's adverse, that antedate the report by more than 7 years. So you cannot report adverse information by more than 7 years.
Wait, go up. What does that say? What the...
Yeah. You cannot report information but for more than 7 years. Okay, adverse information, which is what you're talking
Wait, but okay, but that says charge off accounts placed for collection or charge to profit and loss, which
Yeah.
antedate
Scott,
the report by more than 7
talk
years.
about, give me 1 second, guys. I need to just take a quick relief. Something here. Baby's crying. But Scott, talk about this. I promise I will be right back. Okay, guys?
All right, guys. Does everybody understand what this is about, or is there anybody that has no clue what this is?
Yep.
Anybody not understand?
Interested to see how this one shakes out for you.
Yeah, so I mean, I've looked it
That.
up. The CFPB is a member of the FFIEC, and if you're subject to the supervision of the CFPB, therefore you're subject to, there's about 5 agencies that enforce these. Now, even if I think there is a private right of action for this, but even if there isn't, I'm arguing it's a deceptive,
This
unfair.
does. I mean, what? But
I'll
this,
let Steven talk.
okay, yeah, thank you. I had to
know.
just jump out for a quick second. So what this is saying is that information cannot be reported if it's adverse, and and older than 7 years. But then you go down to CC, not to be confused with the FDCPA CC. This is the FCRA CC. Look at that. Aha, now you CC. Okay, I took it too far there, guys. The 7 year period in 4 and 6, actually 4 and 6, excuse me. My bad, I was reading the wrong one. This is the one, accounts placed for collection or charged. Okay, charged off. This is the one right here. So for 7 years, collections and charge offs. And CC, the 7 year period above, basically shall begin with respect to any delinquent account that is placed for collection internally or by referral. So either placed for collection internally or externally, charged to profit and loss, or subject to any similar action. Okay, so anything that you're kind of delinquent on is going to be subject to a similar action because they're going to want to bring you back into conformity with the terms of the loan. Can we agree on that? So, I mean, they're not going to be like, oh, this guy's 131 days late. We're just going to, I mean, if they sit back, they would have to like give them a forbearance or modify the loan. Other than that, it's going to be subjected to this. If you
Their argument here would be, well, we didn't charge it to a profit or loss.
Yeah, or subjected to any similar action. And so then it's like, okay, well, I mean, if you look at the agreement, I mean, the agreement states that consumers required to pay whatever 60 monthly payments of $350 a month or whatever that car contract says, right? So the issue is subject to any similar, and the whole spirit of this is to keep credit acceptance from doing exactly what credit acceptance is doing, which is if they're going to say, well, we didn't place it to any subject similar, okay, well, great. Well, then, so how in the F are you reporting it as late? Because what you're telling me is that I'm in conformity with the agreement somehow. You must have given me a modification, and I don't have that for my record. So give me the modification, telling me I can just pay you when I want to. Apart from that, I can't just pay you when I want to because the signed agreement says it's 60 monthly payments, monthly of $350. And if not, my ass is in default. Okay, so they can't tell you that. And if they tell you that, then you need to go back, Scott. And this is good because I know
What
you're
about the law that says he must report the date of first delinquency? Which one's that?
Yeah, so that's very good. So you want to go to this right here, CC for this is basically the what you would call the definition of the description. This isn't really a definition, but this was what you would call the description of the date of first delinquency. This is where the concept of the date of first delinquency is described. Okay. So then to your point though, 15 USC 1681 S-2A. Now there's no private right of action for S-2A.
Doesn't matter. I can do it as a Florida deceptive, unfair, and trade practice.
Unless they're reporting false information with malice or willful intent to injure. But then
well, then I can't. Then there's that too. Yeah, I can. They absolutely are.
So you can at least plead it, but then
I'll plead both.
Prove that shit. So then we go up in here, Control F.
They're really doing it because they're publicly traded and they don't want losses on the books. I mean, they want to inflate the profits as much as possible. So if you never charge off the account, your profits are always going to be higher, which is SEC violations.
So down here, F. Let's see. Now that's the COVID pandemic. Duty to provide notice of delinquency of an account. A person who furnishes a furnisher, credit acceptance, regarding delinquent accounts being placed for collection, charged to notice. This is the exact language of the description of the date of first delinquency, right? Placed for collection, charged to profit or loss or similar action. We go back here. Placed for collection, charge to profit or loss for the subject to similar action. Okay, so this describes the concept, and then this refers back to that because they're both describing the same thing, right? I mean, it doesn't call it the date of first delinquency, but that's what this is being described as. Okay. Or subject to any similar action shall not later than 90 days after furnishing the information notify the CRA of the delinquency on the account, which shall be the month and year of the beginning of the delinquency of the account that immediately preceded the action, which also is basically the same language here. The date of commencement of the delinquency, which immediately preceded the collection activity. Okay. Preceded the action / collection activity. So we can see that this is talking about the exact same thing. So to your question, Scott, 1681 S-2A5 is where that is. Okay.
No, I'm talking about where it says that they must report the date of first delinquency.
That's what Isn't this is telling. That's what this says right here. This says a furnisher, person is a furnisher, a person who furnishes a furnisher.
It doesn't say
they must furnish the date of first delinquency within 90 days of furnishing the trade line. Okay, so if a trade line is
after it's charged off, though, that's what they're going to argue. It's after it's charged to profit or loss. They're going to say we didn't charge it to a profit or loss. So
or subject to any similar action. Okay.
But a similar action would be something similar to a collection charge off, like a repo or foreclosure. Or, they would have
to argue that this thing is not in any sort of a collection or similar action, in which case, if it's not in a collection or similar action, then they can't be reporting it as delinquent.
I thought there was a law that said that they just had to report the date of first delinquency, like without being collection charge off, just in general.
Well, the
I
date of
guess not.
first delinquency by nature, if we go back, okay, so I mean, number one,
Yeah,
this
it has to
kind
have
of has
yeah.
this kind of has the same language as this, okay, and they're both talking about negative accounts, okay, because remember, positive accounts can stay in your credit report indefinitely. Okay, did we know that? In positive accounts can stay in indefinitely. There is no, requirements relating to information excluded. If you guys look through this, I mean, this is bankruptcy, civil suits judgments, which is negative, tax liens, which is negative, collections, charge-offs, and similar, 7 years, adverse, which is negative, medical, furnisher, blah, 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 blah. Veterans medical debts, which is, going to be negative collections. So there is no limitation on the reporting of positive information. Okay. And then also, this is often overlooked, especially if you're disputing mortgages and things like that. A credit transaction over $150,000 is exempted. Okay. So you can have a fork. This is really important, actually. Like, I've never really seen this come up, but if the other side knew what they were doing, it would come up as defend if you sue on a foreclosure and say, oh well, I mean, I don't know. Of course, I guess it was over 7.5 years old. Basically, you could have an accurate negative loan of 150,000 and more, i.e., mortgages are typically what we're going to see, right? They're exempted. Okay, a lot of people don't really. You could have a 30-year-old charged off $200,000 loan as long as it's accurate and complete. There is no purge on that. Okay. So this basically says 1681CA, hey, all these negative items are excluded from reporting after a certain date. Okay. This says, notwithstanding that, regardless of that, these following things, even if they're negative, are excluded. So they can report forever. And then this says the running of the reporting period. Okay, so the 7-year period, which I was giving you kudos. I don't know if you had plugged in or not yet, but you had said 7 years plus 180 days, right? So you actually got that right. So the 7-year period starts no later than 180 days. This is for credit reporting purposes. And that's important to note for what you're arguing in this whole thing, is that there's the charge-off policy, which we haven't even gotten to yet, which is your next screenshot. There's that charge-off policy, which says it needs to be charged off internally for their accounting purposes after 120 days. Then there is a credit reporting requirement, which says for credit reporting purposes, regardless of what they do, whether it's charged off, collections, or anything similar, Credit Acceptance Corporation would fall into that anything similar, because any negative notation would make it anything similar. It cannot be negative and not be anything similar to collection or charge off, because the negative notation makes it adverse and outside of the terms of payment by what they're reporting. So they can call. I mean, that's exactly what you need to tell the mediator if they try to play that game. You're on. This is why Congress basically put that in there. That's the catch-all. So credit acceptance doesn't sit here and play games. Okay, how can it be reporting 3 years of freaking late payments never paid, but they're saying it was never placed for collection or anything similar internally? Their credit reporting indicates it was placed for something similar because
They could
there's
report it late for 100 years, 180 days late for 100 years.
yeah, and that indicates collection, charge off, or something similar. It indicates that they want their money. That's what that indicates, right? So
I mean,
that is a collection.
it's
Okay,
obviously not accurate,
right,
even though it's technically accurate, it's inaccurate.
right.
What's that saying? Technically something, but something,
The technical accuracy, but technically accurate.
but
In
misleading or something. I forget what the saying was.
Yeah, so the technically accurate, if you look at the NCLC, it basically says that that's not enough because maximum possible accuracy is the standard. So, and I mean, so it's misleading from the report this thing 3 years late, but then to tell the mediator, oh, well, it was
So,
never in collection, Okay, well, then make all those payments back to pays as agreed. Even if I didn't make a payment for 3 years, if you're saying I wasn't in internal collections and I wasn't in something similar, well, okay. And then obviously you're saying I was within the terms. So if I was within the terms without making a payment for 3 years, that's cool. report me as such, which would be convert all my 180 days to currents. Okay, that's what you would need to say there. They're going to say it wasn't something similar. Okay, but it sounds like if we go back to your screenshots, well, from the prior slide, it sounds like the guy was like, hey, show me something, under the law or whatever. So you're writing this phenomenal letter here, which I was giving you props on as you were joining, because you said 180 days plus the 7 years, and almost nobody remembers that, right? Okay, also the date was charged off will be noted and never changed. So it will continue to report as a charge off, but it will be an old charge off after several years while your client keeps it alive indefinitely. With how your client is reporting the account, there never is a date of first delinquency because they don't charge it off. That's where we were. Okay, that's what we were trying to say right there. So if we go back here, the way that you frame that thing up is you're kind of playing games back with them from the way I read that, because there has to be a date of first delinquency, because if we go back to what you asked for, they literally have to report within 90 days. And by virtue of it being a negative account collection account that is not exempted, right? It's under 150, let's see, credit transactions under 150,000. So it's not exempted. And it's placed for collection, charged off, or anything similar, which down here, anything similar says for similar action. Okay, so you're basically saying, hey, if we go back to what you're saying, let's see here. With how your client is reporting the account, there never is a date of first delinquency because they don't charge it off. I mean, you're basically saying, well, what I'm going to say you should be saying here is, dear credit acceptance, if you're saying this was never charged off or anything similar, then there cannot be a date of first delinquency. And there has to be a date of first delinquency if it's adverse, because we just read it. And so is it adverse, which requires a date of first delinquency, which requires to be in collection, or is it not adverse? So if it's not adverse, there's no date of first delinquency. If it is adverse, there's a date of first delinquency. Okay, so having 180 plus payments reporting your credit each month is far worse than having an account charged off a year ago. See, now you're bringing it to damages, which is nice. You're not bringing it to just like your reporting is wrong. Now you're bringing it back to the real life. Yeah, it's worse for my credit worthiness when I go and try to use my credit, because they're like, why has this thing been 180 days late for 3.5 years versus no reporting for 3.5 years because it charged off 3 years ago or whatever, right? The 180 plus late payments being reported each month is extremely damaging because it is based on an assumption that an account will only report those late payments for a maximum of 4 or 6 months, which is what we're going to, the charge-off policy, which is not the FCRA requires. The consumer is constantly stuck in the window of when an account is heading to charge off, but hasn't yet. But again, there's that similar action. So he's within the similar action, but maybe not yet charged off. But again, the sweeping language that they put in there, similar action, charge off, or collection, right? So it's all, if it's adverse, it goes under that similar action. Okay. There obviously must be a limit for how long you can continue to report the account late before it must be charged off. You can't stick a consumer with a never-ending late account. I saw one client who had credit acceptance report him late for 6 years. Okay. All right. Congress has a clear intent for having limits on how long derogatory. Very nice. Again, you're going back to the CC, the FCRA CC. Derogatory information can continue to report as well. Rule set forth above. Since your client is subject to the supervision of the CFPB, they are then subject to the rules above. Okay. Now we're going to go next. So there is this charge-off policy. It's called the Federal Financial Institution Regulators. The hell's it called? Revised Policy for Classifying Retail Credits. There we go. It's been around for a while. No, actually, this is what it's called. Excuse me. I knew that looked funny. The Uniform Retail Credit Classification and Account Management Policy. That's what this is called. Okay, so this policy sets forth that accounts as exactly you're saying, because this policy has been adopted by multiple regulators. Okay, so accounts that are subject to the regulation of those regulators.
And this was before the CFPB was created. This is in 1999. So that's why the CFPB isn't in there, but they are a member of the FFIEC.
Yeah. So there you go. Exactly right. So
and those other organizations above them. But yeah, the policy's right there in that second paragraph.
Yeah. So right here. So the revised policy retains and clarifies the requirement that open-end loans, which would be like credit cards, that are 180 days or more overdue should be charged off. Closed-ended loans, which are things like mortgages, auto loans, such as installments, should be charged off after 180 days of delinquent. Okay.
That's it.
20 days. That's it right there.
That's it. Game over.
Okay. So this is the policy. And I guess it's not in here, but here you go. Let's see. There's a list of the regulators somewhere, but that's not the point. The point
and you know what I'm going to do too? For the 3-4 years they reported him late, I'm going to get them to add up all the late fees and credit him back. On top of that, he can't get a car, damages for that. I mean, why not? He shouldn't have been charged those late fees. Should have been charged off a long time ago. He couldn't get his house.
Hit him good.
Couldn't get a car. I mean, it's ridiculous. It's true, though. I mean, they really screwed this guy. And I've seen this happen to other people. I've been wondering what to do with this for a long time. Now I'm finally with the arbitration and all these great courses, finally able to shove my foot in someone's ass.
I do work for testimonials, Scott. So give me a good testimonial. So here's the list of the regulators. Office of the Controller of Currency. These are the ones who have adopted this uniform policy. The OCC, the FDIC, the Board of the Federal Reserve, Office of Thrift Supervision, FFIEC, and then, like you said, the CFPB has been added since then because this was from 1999. Okay, so you have this policy right here, which was adopted by regulators, including the CFPB, which mandates that that the collection of accounts for any financial institution that they regulate must conform to this charge off. And the reason really is, I mean, for conformity of cleanliness of the books, basically. I mean, you don't want to go into a bank, right? Because you've got the FDIC, they're the ones that insure banks, and have a bank exactly like this. Let's say Credit Acceptance was a bank. Okay. You don't want to have this thing reporting as a positive, good performing asset on their books, right? Like, so this thing forces them to say, okay, after 120 days, 4 months, it's got to be reported as a loss on their books. That way they can't be fluffing up their books with, millions, tens of millions, hundreds of millions of dollars of non-performing assets, still reporting as good assets. Does that make sense? That's the whole real reason behind this thing, is so that their financial accounting is not fluffed up and they properly record their financial accounting to reflect the reasonable expectation of collectability. Okay. And I mean, look, if you've gone 4 months or 6 months, respectively, 6 months of not paying your credit card, you ain't going to pay them, most likely. Right. I mean, that's just reality. Okay. So
and if you do pay it and bring it current, then that starts all over again.
Right. It resets the data. It removes the data first. Right. Is what it does. Yeah. Okay. So you've got this and you basically handle up on Credit Acceptance. This is amazing. Have you heard back from them yet?
Not yet. I'm sure they're deciding what the hell to do.
Yeah, I was going to ask if you heard a response yet.
This is beautiful. This is really, really good stuff. I mean, you've tied it all together, dude.
And I'm filing arbitration now for the FTC cosigner notice. I get a lot of people that are cosigners for autos. And according to the FTC, a cosigner is someone, they have a different definition. It's basically someone had no use of the vehicle, no benefit from the vehicle, even if they're labeled as a, it's basically they were just doing it to help someone with their credit. Well, there's a separate notice on a separate sheet of paper, and it says FTC cosigner notice. Yep. And it says, be aware, by doing this, you could be responsible for the debt. You could be sued. It could end up on your credit report. They have to sign that. Now, that's in the FTC Act, federal. There's no private right of action for it. But in Florida, any violation of the FTC Act, advisory opinions, anything out there, that it's an automatic or per se Florida Deceptive, Unfair Trade Practice Act. So I'm filing under that. No problem. I mean, this is such a huge window. FDCPA violation, automatic. Florida Deceptive Unfair Trade Practices Act. Fair Credit Reporting Act, automatic. Repo, automatic. But I just got to figure out like how do you, in terms of damages, like how do you stack on like damages for that on top of the other stuff? You know what I mean? Like we need a damages expert to come in here to calculate these
We
numbers
do have a
for us.
damages expert, Doug Miner. He's in here, and I've done a lot of Zooms with him. Actually, he's done expert witness for hundreds of cases. So,
Well, we need to holla at Doug Miner.
all right, very good. So great work on that. I mean, literally everything in there was freaking spot on, and that's what pre-lit is all about, is literally knowing what you're talking about. Nothing more complicated. It's not easy because you have to learn, but it's not complicated. You have to learn. All right.
And another thing I'm doing too, by the way,
Yeah.
there's 4 things you can ask for in a repo for supplementary damages of 500 each. So there's 4 things that are 500. So that's $2,000. So I put the 4 things I ask for in a letter, send it certified. If they
Nice.
don't reply, 2,000. They don't reply, 2,000. They don't reply. So I have like a few companies where it's up to like $6,000 or $8,000 where there's no balance owed, but I'm just going to file the arbitration just based on that. Say you owe me 8,000 and
Good stuff.
they're not going to have any choice but to pay it.
Yeah, let's follow some of those if you would be so bold as to do that. I mean, as you go through
Yeah,
them,
I'm starting to
because
file. Like after my first test one is over
yeah,
and I beat it, I was all nervous as shit because I don't want to mess anybody up. And they did a counterclaim for 20,000. I'm like, oh shit, maybe I'm gonna get this lady screwed. And I was like scared as shit. But I came out on top of that. I'm feeling a little bit more confident. So now I'm slowly but surely gonna start ramping things up.
well, there's
And
obviously, I mean, in arbitration, I mean, there's no guarantees, right? Just like with litigation, it could go the wrong way. There's not always that possibility, but I will say with what I just read that you'd put together, I mean, you were spot on, right? And that is like 99 percentile of your top 1%, I would say. Like you can back up everything you said, and that's pre-litigation. So, all right, so that's awesome on that, Scott. Great work. Super proud of you, man. So now let's shift gears. This is really we're gonna have some fun with here. So last week we talked a little bit about FDCPA, and I've got a client file, an account, a debt collection account from Jessica, who's in here. And we talked about it real quick last week on the show, and I was like, send me the client file. Let's take a look. So I've got it. We're going to go through it, and then we're going to kind of put together kind of a final dispute here to tie everything together. And this is a great file. And as you see going through it, it's marked in dispute by the debt collector, but it's actually on one of the bureaus, Experian annual credit report. It shows the historical comments of which goes to show you there's the current reporting and there's all the historical reporting. On the historical reporting, they didn't report it every month. And so it says like it was in dispute from these periods of time and from these periods of time, but not from these periods of time, right? And so how can it have not been in dispute for certain periods of time, right? And with your FDCPA, reporting false information, including not reporting an item, is in dispute, is one of the things. So we're going to tie together a bunch of stuff from last week. This is an account that is showing in dispute, but because they've got the historical, we can actually see the holes in that, and we can use that to the client's advantage. So let's kind of take a look at what we have here. So kind of first what I did here is if you take a look, it's just kind of a file folder. So this is what you're going to want to do when you want to set up a file to have an attorney look at it. You want to get your stuff organized. Now, I am missing some documents, some facts and stuff in here from before, which again is why I want to give a really good paper up for Jessica, what we're going to do here today, because we're missing a lot of stuff. Okay, so we've got to clean it up and get a good fact pattern so we can hand it off to somebody. But what we have is, August 3rd, of this year, we have Equifax dispute results. Okay, so it's kind of in chronological. I kind of numbered them like this so you can see. Okay, so we've got Equifax dispute results and IQ data. This is the trade line we're talking about, and they're just showing consumer disputes this account, but they don't give you that historical data for it. And it's still reporting. Okay, so this is basically a rental lease is what we're dealing with here, and they're collecting on our rental lease $9,000. What this is reporting. Okay, so let's look at what we've got here. Let's like analyze the account itself. So what we have here is we do have the date of first delinquency because this is Equifax, it's 2017. So this is a 6-year-old account. It is showing $9,300 owed, and it is showing in dispute. Okay, so it's showing a balance data as of this year, right? So they keep on reporting it, unpaid, but it's like 6 years old. Okay, but there is a balance. Okay, make note of that because we have a letter from the debt collector stating that they're not attempting to collect on this debt. And we've got a precedent that we're going to talk about that says credit reporting is an attempt to collect a debt. Okay, and we're going to go through that. All right, so we've got this right here in our bag of goodies. IQ data, so that was August 3rd. So there must have been something sent before. And I know Jessica said there was. TransUnion had previously deleted it. So again, I'm missing a bunch of stuff here, but we need to just kind of give it a good pass over because it's coming to me for the first time to help Jessica get this thing handed off for an attorney. Okay, so then we've got the next day, IQ data had filed a response. It looks like there was a complaint must have been filed with the state of, I don't know, whoever this is, some federal bureau, Florida bureau, something. Okay, so IQ data is the debt collector. They're writing this letter to the state of Florida. You know, hey, I guess there was a complaint filed against us, IQ data, to you, Florida regulator, whatever. Okay, so let's read through this. So this is the debt collector responding to the regulator, which I don't have the document that triggered this. Okay, but we have this. So in response to a letter dated June 20th, okay, see, this is June. The most recent thing I've got is August. Okay, so Mr. Customer's accounts were, and it says accounts. Notice that they've got 2 accounts on one of the other bureaus. Okay, were placed with our office April of 2018. And let's go ahead and look back at Equifax. The date assigned they've got is April of 2018. Okay, so that those dates do match. Whoopsie, let's go back here. Okay. To collect final move-out charges owed to client. Okay, the apartment complex. We have reviewed the conversation between Mr. Customer and our office, which is the debt collector, and we found no evidence of misconduct. Our review found our collection specialists offered the consumer the opportunity to discuss his dispute, but no details were ever provided. Okay. We received Mr. Consumer's dispute in September of 2019. So again, we've got years of this thing going back and forth, and I don't have anything from 2019. So again, if you're wanting to hand stuff like this off to an attorney, what we're doing here is what needs to happen. Because I mean, if you just give a bunch of documents like this to an attorney, I mean, most of them are super busy. And right, they're just, you know, we need to give them a reason to look at our file. So we need to just get it all teed up. Okay. So we've got stuff from September of 2019 claiming the accounts were a result of identity fraud. Okay. Now I don't know. Hopefully this consumer did not actually claim fraud. That would be a problem. Okay. So, I mean, that is kind of problematic, but I don't know. Okay. Because I have nothing going back that far. And validation documents, including the first and last pages of this lease. Now that's a problem for them because they only provided the first and last pages. How the hell are you going to provide the first and last pages and not the middle of it? That's a problem. FDCPA, you can't collect on anything not authorized by the contract or authorized by law. Well, where the hell is the contract? Middle of it. Okay. Let's see. The surety deposit bond agreement and final account statement were mailed. So they sent the consumer in 2019, evidently, the first and last pages of the lease, copy of the debt collector's bond, and the final account statement on the account from the apartment complex. Okay, we continue to receive disputes and requests for additional information to fully investigate the consumer's claim of fraud. Again, that is problematic from my position here, wanting to hand this off to a lawyer. We cannot just gloss over that when these people are saying that there was alleged allegations of fraud. Because if it's not fraud, and they're alleging fraud, that's a problem. Mailed to him in 2020. While the consumer has submitted the same copies of the state-issued ID and bill to our office, Both of these were issued after the time of the lease, and the consumer has never submitted any documentation that supports his claim to our office, nor has he elaborated on the nature of his claim. We are unable to determine the account as a result of any fraud. Okay, so that is a problem. If this guy was originally saying, hey, somebody fraudulently opened this up, and I don't know personally, I've got to figure this out. But that is kind of a problem. Okay. I mean, we can't overlook that. I mean, that's again something important for us to note, because if you give this an attorney sues them and they're like, well, Your Honor, or your arbitrator, this guy's been sending us bogus ass disputes for 4 years. And at first, he went from saying fraud to this to that, to now he's suing us. That's a very easy way for you to lose. Okay, so we have to know what we're looking at here. Okay. Okay, so I need to get some more details from Jessica from you on that. But upon receipt of this complaint, which was this year, we reached out to the apartment complex, who confirmed the balances on file as accurate. Our office has ceased actively collecting. Okay, that's important to note right there, because there is this precedent that says that credit reporting is a debt collection action. And we're going to go through that precedent. Okay, so that's why you got to know what you need to know, so you can figure out how you can put together intelligent disputes. I mean, I can't guarantee an attorney's going to want to take this thing for a number of reasons, including this fraud. That really does, I mean, that's kind of a problem. But I can guarantee we're going to put a freaking bang up, smash up pre-lit document together here, right? And that's all we can really do for our clients. Okay, so our clients, so the debt collector has ceased collecting, even though they're reporting it with the balance, which precedent says is debt collection. That's going to be something we're going to throw in. Okay, as this is a time-barred account, so they're acknowledging it's time-barred. However, if the consumer sends any money, it'll be applied. Okay, standard stuff there. Thank you for your opportunity, blah, blah, blah. We love you. Okay, so that's their letter to the regulator. This is the copy, I guess, of April 11th. This was that first document, because remember, if we look at here, it was opened on April of 2018 with the debt collector. So this was their kind of their first notice, I guess. See, 950243, 9321, how is it, okay, 9321 in interest. So, and again, how is all this calculated? If they only sent us the first and last pages of an agreement, that's highly problematic for them. Okay, we need to figure out what we can exploit in a good way. I mean, exploit it in a good way, and that's going to be one thing. Okay, you're sitting here, and it's not like they're just collecting 9321, and on the last page of the contract it said, whatever, just how it calculates your thing. They're adding interest, so we kind of need to have a whole contract. Okay, so this was just the debt collector's first letter, the typical 1692 GA letter. Okay, this is, let's see, some claim process form. Looks like the apartment complex filed a claim. $1,750, I guess, was paid by the apartments for damages. Surety deposit. Okay, so there was a $1,750 surety, I guess, secure deposit or something like that. And then the amount due is $9,321. Okay, so that's their claim, I guess. And here's a rundown starting from oldest, so March of 2017. Here's kind of their, now I have not gone through with a fine-tooth comb and looked at every line item here, but they did give you kind of some sort of a line item breakdown, which is, kind of okay. But then here's interesting. In 9403, but then you got things scribbled and stuff. Okay, if this came from the apartment complex, all scribbled and strike through. Write-offs prior to being sent to collection, 9403, 1668. Correct amount correction needs to be made to down. Okay, I mean, so they've got stuff with handwritten notes on it. That's not necessarily too convincing to me. Okay, and here's the lease. You've got a first page and, okay, the amount of your lease. Page 1 of 7, and DocuSigned, and you've got a last page of the lease, page 7 of 7. So as they admitted, they don't have a complete document. All right. So that's this document. So on 8.3, we had this dispute resolved from Equifax. I don't have that dispute. On 8.4, there was a document from the debt collector to some regulator. Okay. And then on 8.30, another Equifax. Let's see here. Dispute to Equifax from the consumer, request to provide method of verification. Okay, tell me what you previously did. Basically, your method of valid verification request to Equifax. That's on 8.30. Okay, USPS certified, to track that thing to Equifax. 9.15, Equifax response. Let's see here. Now, this is interesting. I saw a bunch of these during COVID. This is really interesting. So they're saying Equifax is saying we're unable to locate your credit file. But then notice they say Equifax Canada. So somehow, and I've seen this letter before, Equifax is, when they receive this person's letter, they're trying to find a Canadian credit file. So they're saying this guy doesn't have a credit file, but then they're talking about Equifax Canada. That's like an issue, isn't it, guys? Okay. So that's kind of September-ish. And then let's see, October Equifax credit report. Okay, here's the Equifax credit report. Consumer disputes this account, but that's only the current status. It doesn't show any historical information. Okay. Your date of first delinquency is still 2017. Here's your amounts, your original amounts, and your amount. Okay, so that's your Equifax annual credit report. Great work, Jessica, on getting those annual reports, by the way. And your Experian report from October as well. Great work getting this. Okay, so there's some good gems in this one. Now, this one here, let's go down. The trade line, there's actually two separate trade lines. Okay, there's the main IQ data. And see, look at this. There's missing monthly payments. The assumption here that we make is that they just did not report on these months. Okay. And to collect a debt, we can make the assumption that they have to agree with the bureaus to report Metro 2, because the bureaus, their policy is to contractually require furnishers, including debt collectors, that they will report in Metro 2. And Metro 2 has a standard, a manual that says they must report monthly. So if the debt collector has contractually agreed with the bureaus as a condition of reporting that they're going to conform to their industry standard, and they don't, that's deceptive, which is a violation of the FDCPA. There's not a case law on this specifically, but again, they're all different, and case law has to get made. I mean, how can they have the privilege of reporting based on a contractual agreement to do certain things, and then they don't do those things? And there's this precedent we're going to go over that says credit reporting is debt collection. Okay. So we're missing a bunch of months. Okay. But here's what I want to show you is down here. Okay. There's this comments section. Okay. Okay. Your previous comments, account disputed by the consumer. Here, look at the months. Okay. September 2023, May of 2023 to July. So so May, June, and July. But see, then there's a space here. Okay. March of 21 to March of 23. So April of 23 is missing, right? We go from March of 2023, April's missing, to May of 23, and in July, there's no August, and then September, right? And we go back up here. I mean, you've got it reporting here. Let's go back down here. So you've got it. So here it's interesting because April of 2023 is missing, and August, May, and okay, April and August, the A's are missing. Interesting here. April is showing as a collection, but August and here is no data for the payment history. So, I mean, first I was thinking maybe they just didn't report it, but what the hell? They did report the payment history. So they're going to report it has to be monthly, which is the industry standard requirement. Okay, so here we have a trade line that is showing in dispute. But because we've got the Experian, we can see that they're actually giving the historical reporting. So the question is, are they suggesting that this account was not in dispute in April and in August? That's the question, because this reporting would indicate that. You see what I mean there? Okay. Okay, so that's what we have to work with. Okay, so now we're going to take some tools out of our toolbox. If we go to our training course group, let's see here. You've got guide number 52 with some sample affidavit language. Okay, and so I'm going to suggest that we turn this dispute into an affidavit. And then we can just kind of cherry pick this affidavit signature section here, which was downloaded from what I've got in the group. We've got the Metro 2 manual. Okay, and we're going to go over real quick in this Metro 2 manual. Again, for a furnisher, including a debt collector, to have the privilege of reporting to the bureaus contractually require. We make the assumption that they do, right? And then, I mean, this would come out as a yes in depositions, right? Because I technically at this point have no firsthand knowledge of IQ Data's relationship with the bureaus, but we make the assumption that based on the bureau's policy, IQ Data should have been required to report, to sign contractually with the bureaus that they're going to conform to Metro 2. And conform to Metro 2, they have the reporting guide, okay? And if we go down here to section 2, industry reporting standards, all accounts must be reported a minimum of once per month, okay? So we have a debt collector that we make the assumption contractually agreed in order to report credit, which is a debt collection activity based on the precedent. So in order to use credit reporting to collect on a debt, they agree to report monthly, and they're not reporting monthly. Okay, so that's a deceptive activity in relation to the reporting of a debt. Excuse me, the collection of a debt. Okay, that we're putting this together like this. Okay, so. And again, once you guys do this, I mean, you can get your templates and your snippets. We're just kind of going through here, so you get the idea. But there we go. Okay, so that's how we use Metro 2. All those people who say their attorneys don't ever need no Metro 2 or whatever, well, Metro 2 is the industry standard, and it's contractually agreed to by these debt collectors. Okay. And then I've got my little notes right here. Okay, there's this amazing precedent, okay, called Escobar versus Midland Credit Management. And then I've got the sections of the FDCPA here that Midland Credit. So basically, in this case, Midland Credit, so the precedent was set that credit reporting is a debt collection. Now, in this case, the account had been paid for and not marked as paid. It still had a balance. So it's a little different than this, but we have a letter where the debt collector says, hey, this thing we've ceased collecting on it. We're not collecting. So how can you not be collecting when you're using credit reporting as a debt collection tool and you're showing a balance? So again, it's about taking these precedents and making, basically saying, hey, our fact pattern essentially fits this already successfully argued. Okay, so you've got Escobar. Let's open here. Escobar versus Midland. You guys can read through this, but basically you go down here and they tie together in FDCPA. Let's go down here. Let's come down. Okay, so they tie together, okay, 1692E2, the false representation of the character, amount, or legal status of a debt. So they're tying together 1692E2, 1692E8, which we know, if we've been out in the pre-lit world, this is the communicating or threatening to communicate to any person credit information which is known or which should be known to be false. And if they contractually signed off to the bureaus to conform to Metro 2, in that manual it says it must be monthly, they should have known that they're reporting false credit information, right? And then, of course, this is really what everybody just focuses on, including the failure to communicate that a disputed debt is in dispute. But that's only half of it. And then we have those months where it's missing. Okay, so we have multiple ways to weave this in. The use of, and then 1692E10, the use of any false representation or deceptive means to collect or attempt to collect any debt. Okay, this is important because this precedent says credit reporting is debt collection activity. And I'm saying, okay, well, they have contractually agreed with the bureaus to have the privilege of using the bureaus as a debt collection tool. And they're not conforming to their contractual agreement. That is they falsely representative or use deceptive means to collect the debt. Okay, because they were deceptive to the bureaus because they said, yeah, wink, wink, bureaus, we're going to conform to your standard, but we're really not. And this precedent says that reporting is debt collection. Okay. And so the use of any false representation or deceptive means to collect any debt, which this precedent says. Okay. So that's just 1692E2, 8, and 10. This is very, very important to be able to wire these three together. And then down here, you've got 1692F somewhere in here. 1692F1. 1692F1. Attempt to collect an amount that was not expressly authorized by the agreement creating Escobar's debt or permitted by law. Okay, again, this is because this is what the FDCPA says. And we have a contract that's missing, and they admitted that it's missing a bunch of pages. And so this is what we're going to do here. Okay, but actually, let me go back real quick to the Experian report, because if you guys recall, I said it's reporting twice. So this is the first trade line reporting on his Experian. Let me kind of make this smaller. And then there's a second trade line altogether different, the 1750, which I don't know if this was, when we looked at the other document, it showed 1750. It kind of looked like a surety deposit, but I don't know why they're collecting it if it was a surety deposit. So, but they've thrown a second trade line on this client's credit report. Okay. And we'll just kind of look real quick here at what we had just looked at in Escobar. So if we go to 1692, first we'll go to F. Okay. 1692 F1. Okay. So unfair practice is unfair, the collection of any amount, including any interest, fee, or charge, and they are collecting interest. So we need to make darn sure we've got a full contract and we know how that thing is calculated. Or expense incidental to the principal obligation unless such amount is expressly authorized either by the agreement, which they literally gave us a chopped up half of an agreement, or permitted by law. Okay. So what law are they saying then that they're using? Okay, so that's 1692F. And then if we go back, E, they pulled together the false representation of the character, amount, or legal status of the debt. That was, remember, E2 was in here when we went back up to this right here. Okay, 1692E2, the false representation of the character of the debt, E8, communicating or threatening to communicate to any person credit information which is known or should be known to be false. Notice it says nothing about disputing. People overlook this half of it, or including the failure to communicate a dispute. So it's, you can do one or the other, or both. Okay, and then they had put in E10, the use of any false representation or deceptive means to collect on a debt. Okay, and again, they've contractually agreed. That's, unless they prove otherwise, that's the industry standard, is the bureaus require furnishers to contractually commit to conform to Metro 2. Metro 2, as we went over here, I know we're going over kind of fast, but again, says all accounts must be reported once per month, literally industry reporting standards. Okay, so if they contractually agreed to be able to report, saying that they were going to report monthly, and they're using the reporting as a debt collection tool, which is what this precedent makes it very clear. It seems reasonable to me to make an argument, hey, Your Honor, they use deceptive means to collect the debt because they're using credit reporting as a tool to collect the debt. But in order to be able to have the privilege of using credit reporting as a tool to collect the debt, the credit reporting companies require them to conform to their standard, which requires monthly reporting, which this thing does not have. Okay, and again, if we look back at these reports, and they're all different, but this thing is missing a bunch of monthly reporting, no datas. You guys see that? And then we go up to this other one, it's got a bunch of missing, no data. And we go back down here where it was showing in dispute, it's missing months. Okay, so clearly it's not reporting monthly. Okay. So that's kind of that. So these are the tools that we're going to work with, the Metro 2 manual. And then I've got this little Excel here, which is just kind of my little notes. I put in green the actual ones that were in the Escobar court opinion. And then this was the language I just copied out of that, the Escobar court opinion that I went down. Okay, so the false representation of the character, amount, or legal status. And this was what I had read to you guys. 69.2E8. Excuse me, 69.2E2. Then we have 69.2E8. Communicating to any person. Communicating to any person, which is the CRAs. That is very, very, very important. Let's go back here to our communicating or threatening to communicate to any person credit information. They are communicating to the CRAs credit information, which is known or should be known to be false because it does not conform to what they've contractually agreed to, which is to report monthly. And so there you go. See how that works, right? Okay. All right, so there you go. So, and we go back on this. Okay, so communicating, it doesn't have to be communicated to the consumer, right? Communicating to any person credit information, which is known or should be known to be false. It should be known because their industry standard requires monthly report. And then false representation to collect any debt. Now, again, Escobar, this precedent was a paid account. This one here is not paid, but again, you got to find precedents that work and say, well, here's why what we have matches up to it. And this is a pretty darn good fact pattern here, right? And we have EF in general, use unfair, unconscionable needs to collect any debt. Okay, it's unfair to tell the bureaus, hey, we're going to tell you we're going to report monthly as the privilege, but then we're going to just throw whatever we want to, whenever we want to, not monthly on the credit report. Okay, and your F1, whoopsie, collection of any amount, including interest, blah, 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 expressly authorized in the agreement, which they don't have a complete agreement. Okay, and then I've got like just a little added note here, the requirement to report a date of first delinquency. This is not part of Escobar, but I mean, if you've got a credit report that does not have a date of first delinquency, which Equifax does, Experian does not. We don't know if that issue is coming from the CRA or the furnisher, but there you go. Okay. So here you go. So this is kind of what our tools are going to be in this. So now what we need to do is kind of just put together our dispute letter. So we're going to open up just kind of a new, we'll just start off with this one actually, because I'm going to suggest that this gets sent in as an affidavit. Okay, so we're going to just bring this to another page, enable editing, and I downloaded this from the course. Insert page break. Okay, so we'll go back up here. Okay, so you're going to put two, and we would actually send one version of this to the CRAs and one to the debt collector. So to the CRA, version 1, to IQ data, version 2. Okay. So first what we want to do is just put the fact pattern together. Okay, so that's very important. Again, this came from Jessica. Great work putting this together, coming to me. If you want an attorney to take this first, we've got to organize this thing. Okay, so number one is, let's go back here. So this is our fact pattern right here. Okay, so we're going to just kind of, and then we've got a bunch of holes, if you guys recall, because the IQ data letter went back to 2019. Okay, but so like, on or about, we'll just put 8/3/2023 Equifax dispute results. Okay. And we can fill in the meat and potatoes later. Okay, on or about 8/4/2023 IQ data response to regulator. Okay. On or about, that's kind of how you want to do it, on or about 8/30 2023 dispute letter to Equifax. Okay. So on or about, okay, we can say which was delivered to Equifax on or about, 9/6, right? Okay. See that right there? Right there. Oh, excuse me. Yeah, tracking. Okay. And then we've got the letter Equifax Canada. Okay. So then we've got on or about 9/15/23. Equifax sent a letter stating that they could not locate a file on the consumer. Okay. And then we kind of fast forward to 10/16. Okay. We've got Equifax. And now these are the online reports, which are the full file disclosures. And I'm just putting the skeletons here. Okay. And then we will fill this in Experian. Stop here. Okay. Okay. Now, what are we missing? Okay, let's take a look at IQ data dispute response. Okay, we go to this IQ data dispute response. They give us some details. Okay. Letter dated June 20th. Let me kind of just move this over here, sort of. Okay, move this over here. Okay, so what we're missing, we'll just kind of do this. So this is what we need to figure out. Okay. Because a good attorney, and again, I'm not an attorney, but we're looking to send this off to one, right? They want to know all the answers before they ask the question. So we need to know what the hell is going on here. So missing. Okay, so June, so 6/20. Okay, so we know there was a dispute to IQ data because they state it right in here. Okay. Okay, April 28th. So as part of the fact pattern, here we'll go ahead and do it this way, actually. Okay, and because on or about, again, we need to lay down the whole thing here. So on or about right here, 4/2018. That place for collection with IQ data. Okay. Okay. September of 2019 fraud dispute. So that's definitely problematic. So we're missing that right there. Okay. Let's see here. So it's going to be September 2019. I'm going to put this in ready because we just want to make mental note for ourselves. Like we don't want to get ourselves tripped up here. Let's see. We continue to receive disputes, and the request for additional information to fully investigate the consumer's claim was mailed. Okay, so basically they replied is what had happened here. So what we're missing is the January of 2020 fraud dispute response to consumer from IQ data. Okay, from IQ data. We're missing that. Okay, we don't have any more dates here. Okay. All right. So what we have here is, okay, so then on this right here, no. Okay. The 8/4/2023 IQ data response. Okay, this letter contains response to regulator. Okay, so this document includes a lease agreement with only, here, we'll go back up here. Okay, with only, okay, the first and last pages. This agreement is incomplete. Okay, that's the issue. Okay, we're just kind of bulleted it here a little bit. So this is what we're kind of saying. This agreement is incomplete. No, actually, I'm going to put the bullet in the wrong spot here. Let's go back. Okay, so these are the issues contained in this dispute. Okay. This document states that IQ data has ceased collection efforts. However, the credit reports are still being updated periodically. We'll say periodically because they're not updating them monthly, but they're being updated periodically. Because if we look, you know, here is your Equifax report. Your balance date is October of 2023. Same thing if we go to Experian. They've been updated frequently, but just not monthly. Okay, so we're going to say periodically. And we'll remove these little things there. They cease collection, however, the credit reports are still being updated periodically, which is an attempt to collect a debt. Okay. So these facts we basically kind of ascertained from here. And then we look at our Experian full file disclosure. You know, you can say that, you know, the high points is there is no date of first, no date of first delinquency reporting, which is required under the FCRA and industry standard. Okay. We can also state that although the trade line does report the account to be disputed, it only lists a few of the historical months, and the months which are marked as, you know, we'll say disputed. This is false because the account was continuously in dispute. Without any missing months. And so we're talking about right here, and credit reporting is required to be performed monthly based on the industry standard that IQ data almost certainly is required.
Hey, Steve, quick question, brother.
Jeff, man, I was just thinking I was over here talking to myself.
No, I'm watching you, man. On that second one, although
you're watching me. you're watching me peck like this. So I tell you what,
Yeah,
that's why I do credit repair, because I'm not a good typist. Go ahead, man. What's up?
although the trade, so what you're saying is those ones where they didn't report no data, you could actually kind of claim that they didn't report it as disputed on those months as well.
Well, here's what I'm saying. Very good. Let's go back. And
Because that's an interesting concept. I never considered that.
so, and if we look at the training course, and if you go back to module 2 in the guides, I kind of have like that Excel, and I break down how to read the report. And there's two main parts of your report. There's the current status, and then there's the historical status. Typically we see the payment history, but really all those required fields should be reported historically. And then different of these reports give you different information, which in and of itself, if this were a pure FCRA dispute, is a problem, right? Because it's like they're all inaccurate. Okay. So what we're saying here, though, is if we look at up here, which trade line is this? Is this the right one? Let me just do this really quick here. That's capital one. Okay, so this is the first one. So they're saying down here, just the way that they give this report format. Current status, comments, indisputed. Okay, and the current status is, that's really part of up here, kind of all this stuff, right? As of the date reported, which they don't even really, they give you a balance updated. Again, that's not even really like Metro 2 conformity, but clearly this thing was reported like October of 2023. And for those of you guys watching the replay, today is October 24th, 2023. So it was updated this month. Okay. So down here, this is part of, they're saying as of this month is still currently in dispute. The nice thing about this report is they're saying historically it was disputed from March of 21 to March of 23. There's no April.
Oh, okay.
And from May of 23 to July of 23, there's no August. And then in September, and there's no October, but October is up here. Okay. Now we can definitely make this argument on the other reports. Then you just have to tie it all together where they don't even give you the historical at all, and they're supposed to. Okay, but at least the nice thing about this one is it's like, well, they're giving you the historical, and the historical has clearly got holes in it. Does that make sense, Jeff?
Yeah, gotcha.
So, but yeah, even if the other reports, like if we look at Equifax, consumer disputes, well, where is the historical information? I mean, yeah, this is all jacked up and incomplete as well. Okay, but the nice thing about this one literally, a judge can look at this and be like, well, clearly I can see that, right? The judge can't look at this. He's got to conceptualize what's not there. You with me, Jeff?
Yeah.
All right, sweet. So we go back here then. So credit reporting is required to be performed monthly based on the industry standard. The IQ data almost certainly is required to conform to, in order to have the, it's like, and I didn't say as a matter of fact, okay? Because again, I'm suggesting we turn this into a fact-based affidavit, and I don't know for a fact. I have no firsthand knowledge as a fact that IQ data is required to conform to Metro 2. But I know I can say that they almost certainly are, right? So that is something that you can say because it's not like a statement of fact. It's an opinion. Like, I think they most certainly are. Let's let discovery prove me wrong, okay? That they have, let's see, required to conform in order to have the privilege of reporting credit data to Equifax and Experian. This credit reporting is in fact. Okay, we're going to say this is in fact. I mean, we've got precedents. And again, notice, guys, I'm not quoting any laws, any precedents, but it's behind the scenes. You see what I mean? So I'm just putting the plain thing right here together that you can hand this to 100 lawyers, and then somebody's going to like it. That's the whole point. And then you can go back behind the scenes and be like, oh well, here's how I came to this, Mr. So-and-so. But this is all you need to do is just lay down the facts right here. Okay. And again, this seems like a lot, and this client has this one account. If you've got a client with like 10 or 15 credit accounts, I mean, this stuff here, if you're keeping track of this each round, This maybe takes what 10, 15 minutes around, right? Okay, I've received on this date, and you can just have like a living document, a Word document each round, right? And update it. Oh, we received 8:30, and this is for whatever the following 10 trade lines. Okay. So you don't have to sit here for an hour. I mean, you can. And again, if you're trying to give a case file to an attorney, if you can't spend an hour doing it, you're not going to expect them to take an hour looking at it. Does that make sense? There's the time trade-off. Okay.
You want to do a nice little breakdown along with your submission to an attorney so they can read
right.
the breakdown of events that occurred.
And this is going to be our dispute. And we're turning this fact pattern into the dispute. And so you literally have it all typed up here. And so when you hand this eventually, we're going to cycle through this dispute. And the attorney can look at this and like literally, I mean, they just copy paste this into the suit if they want to do that, because it's all organized. Organized is where we're going here, right? Okay, the credit reporting is in fact, and we'll say this as in fact, because I mean, we've got the precedent that we looked at now. Obviously, there's different circuits, things like that. We all know there's different circuits. One circuit isn't binding on the other, but the point is, we're going to say that it's in fact, credit reporting is in fact a debt collection activity. Okay, and so, and then so from here, hey, Mr. Attorney, it's a deceptive practice for them to have credit reporting as a debt collection and to say that they're going to report monthly and to not do that. Okay. Again, we don't need to get all super sophisticated here, but we need to know exactly how we tie this thing together. Okay. All right. So this is going to be we need to figure out what's going on here. Obviously, we're not going to send like this. I'm typing this for you guys once we get this thing polished up. I mean, we want to have this here if we're going to have an attorney look at it as part of the fact pattern, but we're not going to want to send this to IQ data like, hey, it looks like as an affidavit, I'm telling you, I did a fraud dispute when it was not fraud, but this is for us saying, how do we pre-lit this thing, get the fact pattern together? Okay, so then what we would want to do, and then we've got this affidavit page here. We would have the client sign and notarize this. And the other things we're going to do is, if you take we want to put the trade lines in. Okay, this is multiple pages. Typically what I would do, there's like this screen snipping tool, not that. If you go to your Windows Explorer and type in snip, there's a snipping tool. Let me unclick that thing right there. Boom. There's a snipping tool that you guys can use. Where did I freaking find it here? It's popped up into here. There's this little snipping tool. You can just kind of snip. Now let me go back to the first page. Okay. IQ data. Okay, so we can snip. This is one way. One way is you can convert this PDF to JPEGs. Okay. And then just drag those JPEGs. Another one is you can snip, file, save as. We'll save this to the desktop really quick here. We'll just put, we'll put hearing one. Obviously, we're doing this on the fly, real time, live, and censored for you guys. But what you can do here then is, you want to do this for all disputes, actually. And where you put it is kind of up to you. I'll just say we'll put it maybe insert page break. Okay. And then we're going to just kind of drag, and I'll show you guys here. So there's this JPEG right here. I'll double click it. This is what I just screen clipped. Okay. And you can literally just drag and drop into Word. Boom. Okay. Right there. And then, you can put something like, let's kind of space it down actually. And this requires, you can put like, Experian report dated, I think it was 10/16. You can put this something like this. Okay. Let me delete this again and do it back with this. I think it'll stick now. It popped it to another page, but if we do this, sometimes you have to kind of jiggle it a little. Boom, there we go. It popped up. Okay, so you guys get the point. So now you've got kind of your exhibits. Okay, Experian report. We're going to want to put in the other pages. Okay, and then what I'll do is I'll kind of do a little supplement to this video once I get this letter teed up, and I'll kind of splice it in. We'll put this as a standalone video for people who are outside of this training course. We maybe put this on YouTube or something. But the point is this is pretty much what you're going to want to do. Okay. And then I'll take a little bit of time, kind of finish this thing up, add a little supplement. But this is it. So what do we have here? First is we have, just to kind of recap, we have the facts. The facts are I've got all these documents and I organize them by date. That is a fact. Now what's in these documents may be hearsay, but like I've got a Metro 2 manual and then we've got what we started with. We got the Metro 2 manual, which says, so it's a fact that the Metro 2 manual says reporting should be monthly, but it's an assumption that IQ data is required. So it's important we understand, we want to state the facts, right? So the fact is, I believe IQ data, but it's not a fact that IQ data because I really don't know it until they've been subpoenaed and deposed and discovered and all that stuff. Okay. So we start with the facts, and then, we basically just put together a document of the facts. Where the hell is my document here? Right here. I'll save this. Okay, right there. Boom. And then, you've got your facts. And then notice what we did here. First, we organized the facts, and then we kind of put sort of the violations, if you would. This correspondence contains a lease agreement with only the first and last page. Okay. And then I can put in here, something like, this is reasonable for us to do this. We've got our little cheat sheet here. Okay. And we can say something like, again, we're not quoting like 1692 EF1, but we can say something like, check this out, right? This is how we keep it intelligent. So where you can hand this, theoretically to 100 lawyers or arbitrators, and the one who wants it, right? Because ain't nobody wants your letters when you got, citations of case laws and even the real law. Nobody wants that. They want the facts so that they can then do what their law degree entitles them to do, which is figure out how they're going to strategize and, what precedents they're going to want to do. But here's what we can do. This document includes a lease agreement with only the first and last pages. This agreement is incomplete. So we'll paste in here that thing that I just copied. And again, so this is a statement of fact if it's an affidavit. So the statement of fact would be, it is my understanding that. Okay, so now we're not accusing them of violating any law. We're not even citing the law, but we're quoting the law, but we're not saying we're quoting the law. So it's my understanding that the collection of any amount, and they're trying to collect interest, including the interest fee charge, unless it's amount expressly authorized by the contract for the debt. Where's the word? Okay, let's see, I think I'm missing. So I'm missing some language there. Let's go back again. We are raw and uncut. So F right here. Okay. A violation of this section. So, okay, it is an unfair practice. That's the word we're looking for. Okay. So it is my understanding that, here we go, that it is an unfair debt collection practice for the collection of any amount. And again, you can maybe rewrite it to collect. And again, once you have this the first time, you save this as a snip. And if you get, a little thing like this, I copied this language right here straight up from the Escobar legal opinion. And then what could you do over here? You could have another column over here where you could start to have your little snippets, and then you boom, 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 you're right there, So freaking right here, you could take this, you could have a little paragraph here. This could be like your dispute snippets. You know what I'm saying, guys? You get the point, right? You guys get the point. We'll kind of wrap. There we go. I don't know. I think I just jacked it. No, we're going to cancel. Anyway, I just messed it up, but you get the point, right? So we're kind of doing this in real time, first time. But look, once you do it and you know what you're doing, then you've got all your snippets together. The only thing that will really take time is putting the fact pattern. And again, if you do that after each round, this is not a difficult process. And then you get your snippets and, 1681F in general. It's my understanding that an unfair collection practice for any of amount fees expressly authorized. Okay, boom, there you go. So, okay, so this document states that IQ Data has ceased collection efforts. Okay. However, the credit reports are still being updated periodically. And we can say, again, because we're not wanting to be like accusatory, if that's even a word. We're just a simple consumer statement of facts. So again, you can say that it is my understanding that that it is hold on a second here, okay. So it is my understanding that it is but it is not going to be EF. We're going to go back, excuse me, not EF. It's not F, it's E. It is a false or misleading representation. Okay. It is my understanding that it is a false or debt collection representation. False. I can spell correctly, guys. You're not watching this to learn how to spell. You're watching this to learn how to put good dispute letters. False misleading debt representation. And then we can kind of go back here, to right here. Boom. Okay. And again, we have this Escobar precedent. Is my understanding that it is a false or misleading debt collection representation. I freeform typed this before. Now I'm just going to paste this with exactly the language. Representation to communicate, or threaten. So we'll just kind of make the English look good, right? Threaten to communicate to any person, right? Any person is communicating to the CRA. See that? Credit information which is known or which should be known to be false, including the failure to communicate, blah, blah. Okay, and then there we go. Okay, so this is how we do it. So I'm going to kind of, I'll take a few minutes kind of off of this, but I'll splice the videos together and kind of finish this thing up. Jessica, I'm going to talk with you as well because this is your client. But we're going to do one version, we'll take the meat and potatoes, we'll do a CRA dispute, we'll take another one straight to IQ Data. And look, if they don't delete this thing, I mean, you can't have a better thing teed up to be able to show the client, first of all, number one, look, this is how the issues are. And again, you are not practicing law in this. There's no legal law cited. There's no case law. This is what you need to do. Just state the facts. And if for whatever reason, the attorneys look at this and are like, I don't like it for the following reason. Well, I mean, hey, they're going to make their judgment, right? I mean, there's no guarantees, but it ain't because you just wrote some kind of crazy letter like, the typical credit repair, like prove it or remove it or whatever. So that being said, I'm going to go ahead and stop the share on this. We'll clean this up a little bit. I'll do kind of a supplemental video. I know you guys have been patiently waiting and watching, but any thoughts on this, Jeff, if you're still there, or any other thoughts before we kind of wrap this one up and we kind of continue on with this one next week. All right, Jeff, I see something is happening. You're unmuting, you're flickering, you're thumbs upping. What's up, buddy?
I'm good.
All right. So what are you thinking so far? How do you feel about that?
That was good instruction. No question.
I like that. That's golden, huh? Wait till we see the final polished up letter. It's going to be even more golden. So, all right. Well, very good. So that kind of wraps up our session for today, showing you in real time on the fly with my expletives and all, when I type wrong, how to put together. And again, it took us a while, but once you do this, you find a way to organize your snippets and everything, and you put a process to do this thing together, after each round. And that's a big part of it, is building your business model in a way that's efficient, right? And so, if your model is, hey, I'm not going to do spray and pray. I'm going to, from the very beginning, say, boom, 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 boom. Here's the facts that I can stand on. Take an extra 10, 15 minutes each round. And this is part of what you should do when you onboard the client as well. Like what I don't have in here, because I just don't know, because this is another credit repair owner's client. I'm not dealing with the consumer directly. I don't know the damages for this consumer, right? So on or about so forth date, Mr. Consumer or Mrs. Consumer applied for credit, in 2023 and was declined because of this false credit reporting. You see what I mean? So there's even more things that we can get from the clients as part of the fact pattern to substantiate damages, which I don't have that information. I'd like to get it before I put the final copy. But then again, my point there is for you guys, if you're a consumer or if you're a credit repair owner, or even if you're a lawyer, right, what you're going to do is when you onboard the client, you're going to ask them, what the hell is your goal? Well, I'm trying to get a mortgage. Were you declined? Well, yeah. Okay, well, great. When were you declined? 3 months ago. Okay. Well, on or about 3 months ago date, consumer applied for credit and was adversely affected, was declined because of this, false information. On or about this date, client pulled their credit report and discovered this false information was reporting. On or about this date, consumer thoroughly reviewed the credit and sent a meticulous, painstaking dispute to the bureaus and the furnisher debt collector. On or about this date, Equifax said, hey, F you, we can't find a credit file on you because we looked at the Canada credit file. You see? So this starts with your business model is kind of the takeaway there. And if you're a consumer, just straight up, sit down for an hour and think every activity that happened through the duration of this account. And that's really how you do pre-litigation credit repair on a trade line. Then this is important, on a trade line where the debt collector has sent you proof of contract, but it's missing pages, and where they're reporting account in dispute. So imagine that. We just put together a debt collection 1692 E2, 1692 E8, 1692 E10, 1692 F1. We put together 4 violations of the FDCPA, alleged violations, right? I mean, because again, ultimately the attorney has to take this, but somebody's going to like this. There's no doubt, because it's a bang up job, right? So we've got 4 alleged violations of the FDCPA, and then we're going to send this over to the bureaus, which will give us violations there and through the furnisher through their reinvestigation. But a point is, there's 4 FDCPA violations on a trade line where we have a document from the debt collector saying, hey, here's the contract. But it's missing 90% of the freaking contract. Okay. So we're throwing that against them. And the trade line is showing in dispute, but because Jessica did such a good job pulling the annual reports, the Experian report shows, hey, this literally has got this historical and it's missing historical, which is false because it was in dispute during those missing months, right? So the takeaway here is, we get caught up in, trade line shows in dispute, I'm dead in the water. Well, no, you're not necessarily dead in the water. Oh, I got a validation of debt from the debt collector. I'm dead in the water. Dude, these people sent you a copy of the contract, except that it's not a copy of a complete contract, and that's a problem. And they're trying to collect interest. How the hell do we know how the interest is being calculated? How do we know how the default provision is being calculated? Because we're missing 5 of the 7 pages of the contract, right? And again, FDCPA says they can't collect on an amount that they can't collect under contract agreement or otherwise by law, right? So take that away from this one here, guys, is when you learn how to slice through this, it's reporting in dispute. That's okay. I'm not concerned about that. Let's figure out the angle. Got a copy of the contract, but is it missing pages, right? I mean, so point is if you really know how to slice through FCRA, FDCPA, there's always a way to put together a good pre-lit letter. Again, will the attorney like it? Maybe, maybe not. I think somebody's going to take this for sure, but I can't guarantee the client. But I can guarantee the client somebody's going to look at this as an attorney, right? And you can give this to the client. The client's going to notarize it, right? And at the end of the day, they're going to know that you're doing your job as a CRO, right? And that's ultimately really the benefit here is you're not going to be sitting around in 6 months oh, Mr. Consumer, no, remember that affidavit that you notarized? I mean, you literally swore that was the fact. Okay, so we did our job. I mean, if they're not going to delete it, that's their problem, and we're going to have an attorney look at it. You know what? If our attorney says no, have your own attorney look at it, Mr. Customer. We've basically given you paralegal type services, for credit repair pricing. You know what I'm saying? There's nothing to keep you from taking this package and shopping it with your own attorney if you want to. I don't care, right? Of course, no consumer is going to have that connection, right? I mean, they just don't. But point is from a business model, we have to understand it starts from the intake, interviewing the clients, setting up this thing, beginning properly. And in this case, you guys in this training course, or wherever you find me, CROs, giving me a case like this, which has not been papered up like completely. And the CRO, Jessica, she doesn't have 2019 and 2020, right? We're just missing stuff. And we're missing some disputes, but not a problem, right? You get this thing, you paper up what you can, you figure out what you can, try to turn it into an affidavit as a pure statement of fact, right? Which makes it a new dispute to the debt to the credit bureaus, right? Because they've never received this particular sworn statement type thing. And you send this bad boy off to the debt collector with your signature notarized as a debtor, as the consumer. Let them read this thing and let them, and plus something like this thing's 6 years old, right? Because it went bad in 2018, 2017. We're almost at 7 years. I mean, honestly, guys, how is IQ data going to get this freaking thing once I show you the finished result, but you've already seen the skeleton thus far? How are they going to get this thing? And this thing is, first of all, they're not trying to collect on it. They already said. Secondly, it's almost going to purge off the reports anyway because it's almost 7.5 years old. Dude, they've got to be insane to receive this thing as a notarized sworn statement. Again, there's no fluff in here. It's purely fact, boom. But they've got to be crazy to not delete this. Okay. And I mean, I've known debt collectors to be crazy, but you guys get the point, right? And it's all about
walking the line of having to pay out rather than just delete.
That's exactly right, Jeff. I mean, who in their right mind who says I'm not collecting on it? Their letter says it. They know they're missing pages. And we're pointing this all out to them in the letter without quoting a law. We're literally copying the language of the law, but we're not quoting the law. We're just saying, hey, it seems to me that, boom, deceptive practice to do this. Okay. So yeah, man. So we're gonna go ahead. We're gonna get this thing finished up. We'll wrap up this episode, and I'll get this letter finished up offline. We'll do a little supplement. Any final thoughts, Jeff, Scott, Ray, anybody else in Cyber Wonderland? Going once, going twice. Well, that being said, thank all of you for being part of this training course. We're here to help make your business better. Thank you, Jessica, for providing this opportunity for me to help you. And I will see all of you same time, same place next week. You all be good. Take care. All right. Welcome, everybody, to this week's edition of your credit